to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Betty Baker Marshall. Betty is an attorney with her law practice in Campbell, California. She works a lot in the area of elder law and also in the areas of estate planning and estate and trust administration. And today, Betty and I are going to be talking about some elder law issues. I want to tell you a little bit about Betty. She graduated with her law degree from Santa Clara University in 1991. And I think she sort of got into the elder law area because she did quite a bit of work in public services before. So she was a program and contract manager for Santa Clara County Mental Health back in the early 90s. She was assistant public administrator for the Guardian's Office from 1986 to 1992. And she was also a property officer for the Public Administration and Guardian's Office back 1981 to 1996. Betty's husband also is a professional fiduciary, and so they sort of work together helping clients out with their issues. But Russell, her husband, also has a lot of experience in the public services area working with these people. So anyway, Betty has done a number of things. She and I have known each other for a long time. She's contributed to some chapters for some of the continuing education of the bar materials related to her areas that she works in, and also has given a lot of presentations for different groups and so forth. So anyway, she's very knowledgeable, and that's part of the reason why I asked her to be with me here today. And also Betty and I have worked on some cases together. So anyway, so I'm very pleased to have her here today, and I think that you're going to find this a valuable discussion. So just as a way to get into this, well, first of all, let me say a little caution, as I usually do, and that is this is not intended to be legal advice. This is an introductory discussion related to this area, and so what we want to do is to encourage you to see your own lawyer and your own advisors related to the areas that we're going to be talking about. So also, we're in California. Betty is a California attorney. I'm a California CPA. Our laws in California may be a little bit different from how they are in other parts of the country. And so that's another reason, if you're watching this and you live in another state, that you may want to see an attorney in your area. So, just as a little pre-frame then, again, this a little bit has to do with the stage of life that we're finding so many of us are in these days, and that is the biggest part of our population here in the United States are baby boomers, and that means that we're at the part of life where we're caring for senior parents that we would call the Great Generation. And so they're sort of in their declining years. They need a lot of help right now. And so they have needs related to long-term care and so forth that we're wrestling with. And so that's a little bit about what Betty and I are going to be talking about today. So with that, Betty, let's get on with a few of the questions here. So first, what is a durable power of attorney for health care?
A durable power of attorney for health care is a document that is created usually by an attorney, although there are pre-printed forms, and signed by a person who we will call after this a principal. So it's their principal document, they're the principal of it. And in that document, they're appointing a person as an agent to make health care decisions for them. Mm-hmm. You see this most often for people who are elderly and thinking about their medical needs and end of life. But it is a very useful document for anyone to do because we never know what's going to happen. You can't create a power of attorney for someone else. You have to do only your own. There are other provisions for people who want to get health care powers over someone who hasn't created a document like this. which we can talk about later. And they will survive the incapacity of the person who creates them if they are durable powers of attorney. That's under California law. Now, having said that, they are revocable by the person who...
So the big part about this, I guess, basically is it enables a family member, a friend, a trusted person to make healthcare decisions for you. And if you're in a situation where you're incapacitated or you can't really make decisions yourself, then that can be a real helpful thing in providing some directions for doctors and so forth. Of course, related to that, it's really important to make your feelings known to these people as far as, you know, what you want done, because you may have a little different philosophy, if you will. Yeah.
Right. I think one of the most important parts of this is the process of doing it, not just filling out the paper, but having conversations with the family or whoever that person is that you're going to appoint as an agent. And if you have successors in case they can't do it, then those people too, so that they understand your values, because we really can't predict what will happen or what the circumstances might be. So they need to have some understanding of what you would want.
Right. And but these conversations may not happen, and so that's part of the reason for you and I to talk about this now, to tell people, you know, that you should be doing this, because what will happen is this is a document that is typically put together when you're having estate planning documents done, like a will and a trust. And so people are doing all these things and filling out a lot of paperwork, and they may not be giving maybe quite as much thought to them as they should be. And again, to make them really work well for you, there needs to be some communication that happens with your family.
Yes, there does. And you're right, sometimes these are included in a package of papers and they don't get much notice. In fact, people frequently come in and ask to have their estate plans done and don't ask for this document. Interestingly, I had a recent client who didn't ask for this, and I included it, and you know, it provoked a conversation for her and her family, and she said, "This is great. I didn't ask for it, but I'm really grateful." So I think the attorney who is preparing the estate plan should be aware that they need to educate their client about just making a process out of this, not just a paper.
Yeah, there should be a conversation that's going on, and so, and that's the danger sometimes. You know, there are these software programs I'll throw out, that are available to write your own will and your own trust, but they may not bring up these things. And also, again, as we said, from state to state and so forth, you may have certain requirements that you have to meet in order for these things to be effective. And if you're dealing like with an old piece of software or what, it just may not be appropriate. So.
Well, right. If you take a look at the forms, and there's a standard form that's prescribed by the probate code, but you don't have to use that. And then there are forms that the Medical Association puts out, and they're all quite good, but they're generally fill in the blanks and check the box kinds of things. But what people should be aware of is that they can put anything they want as a statement about their wishes and their thoughts in there, attach it as a separate paper, or write it into one of the open areas that's provided.
Yeah.